Thank you all for coming today to this public policy conference on the time for regulatory reform in Congress. My name is Naomi Rao, and I'm the director and founder of the Center for the Study of the Administrative State. I'm also a professor at the Antonin Scalia Law School at George Mason University. This conference is sponsored by my center, and it's also sponsored by the American Bar Association section on administrative law and regulatory practice. So let me just say a little bit about the sponsors and about the format of the conference. The ABA section of Administrative Law and Regulatory Practice is a robust group for lawyers in private practice, government, and academia. It has a tremendous offering of conferences and programs on a range of issues relating to administrative law. Moreover, it has a number of publications and an excellent notice and comment blog, which is a must-read for administrative law types. As a nonpartisan group, the section aims to promote the best practices in administrative law, such as in its report to the President-elect this past fall. The Center for the Study of the Administrative State is an academic institution at the Scalia Law School, and it's committed to rethinking the foundations of the administrative state. We are interested in examining the political, legal, and constitutional accountability of administration, and in bringing together people with different perspectives to think through some of these difficult problems. The Center commissions original academic research, and it also hosts public policy conferences such as this one to bring ideas into the public debate. So our conference today seems especially timely. In the past few months, the administrative state is very much in the air and perhaps even in the crosshairs of the new administration and Congress. With the President and Congress publicly committed to regulatory reform, perhaps the time has really come. So today we have two panels of experts who have a wealth of experience drawn from academia, the Hill, the executive branch, and private practice. We hope to have a lively discussion on these issues, and we will leave some time for your questions. Immediately following the two panels, Senator Mike Lee will join us for a keynote speech. This will be followed by lunch. I want to say a special thanks to Chris Walker, professor at Ohio State Law School, for helping me to organize this conference, and to Leah Verbitsky, for the center's event specialist who coordinates the logistics for all our events. So on behalf of the ABA Administrative Law section and the Center for the Study of the Administrative State, thank you all for being a part of this conference. And with that, we're going to get started with our first panel, which I will be moderating, so you get to hear from me. Again. We've circulated everybody's biographical information, so I just want to briefly introduce our panelists in the order that they will be speaking. So we're going to be starting with Todd Graziano, who is the Executive Director and Senior Fellow in Constitutional Law at the Pacific Legal Foundation's DC Center. He will be followed by Matt Owen, who is the Staff Director and Chief Counsel of the U.S. Senate Permanent Subcommittee on Investigations. And then next we will have Jonathan Adler, who is the John Verheij Memorial Professor of Law and Director of the Center for Business Law and Regulation at Case Western Reserve School of Law. And then finally we'll have Jonathan Siegel, who is the F. Elwood and Eleanor Davis Research Professor of Law at George Washington University. Thank you very much. And with that, we will start with you, Todd.
No.
No?
Matt and I are overruling you. Matt will, we think it's a little more logical. He's going to talk about CRA traditional, and I'll do the, whatever, galactic congressional review.
Naomi, your conference has gone off the rails from the first minute.
I know. My panelists are revolting.
You have an unruly panel. So good morning, everyone. Thank you for having me. My name is Matt Owen. I am the Staff Director of the Permanent Subcommittee on Investigations, which is a subcommittee of the Homeland Security and Governmental Affairs Committee, on which my boss, Senator Portman, sits. He's the chairman of PSI. I'm supposed to begin with a disclaimer that the views I express today are entirely my own, and I promise you that that is true because I have not told the chairman anything that I am about to say. So as we begin talking about congressional review of administrative action, the way I'd like to frame the matter is as follows. Proponents or champions of the need for robust agency involvement in regulation and lawmaking will tell you, and they are right, that the government will not easily function unless the executive branch, through its administrative agencies, can take action that Congress is too encumbered by time constraints and political pressures to take, or that is too detailed or low level to warrant consideration by the legislature. On the other hand, in our constitutional order, the traditional understanding of the separation of powers is that Congress writes the laws and the executive executes the laws, and the judges interpret and in some ways enforce the laws through particular judgments in particular cases. This leads to a kind of paradox. The paradox is that agency action, in order to fit into our constitutional separation of powers, needs to be seen as legitimate. And the argument for its legitimacy ultimately is that agency action is subject to control by the Congress. If Congress doesn't like what an agency did in an important policy area, Congress can change that action. Of course, the problem is that the whole theory, right, is that Congress is too encumbered to make all kinds of decisions that agencies make day to day. And so the question is, are they also too encumbered by political considerations or time constraints to exercise the kind of oversight and control and revision of agency action that would be necessary for them for agencies to sort of fit into our democratic constitutional order. The current attempt under existing law, which most of you know is called the Congressional Review Act. The Congressional Review Act is a procedure that Congress enacted many years ago to allow expedited consideration of legislation to overturn major agency rules. The Congressional Review Act has, there's a lot of complicated questions about it that are unresolved by the courts because it's almost never been used. Until now, it had only been used one time to overturn a Clinton-era administrative regulation about ergonomics, which is, like chairs that help your back and things like that, that the incoming administration did not like. So if you think about it now, you'll read in the paper that Congress is going to consider and maybe pass between 10 or 15 Congressional Review Act resolutions, which, when they go into effect and are then signed by the President, will have the effect of canceling and eliminating prior executive action by the Obama administration and barring agencies from enacting substantially similar rules in the future. But because they require the President's signature, these resolutions of disapproval really only function, if you think about it, as a kind of very tedious and inefficient midnight rules law, right? It means it's really only function in our, practically in Congress, is that if the government changes hands from one party to another, some rules enacted by the outgoing President can be overturned if they are sufficiently recent under the Act by the new by the Congress and the new administration, because the new President might actually sign those resolutions of disapproval. If the President is of the same party or the same person whose administration enacted the regulation in the first place, he'll veto the resolution of disapproval, so there's no ability to set aside the regulation. So that's where we are now with the CRA. The President has signed 2 resolutions of disapproval so far. One invalidates a rule about the Social Security Administration about veterans and their ability to retain control of their Second Amendment gun rights. The other is a Dodd-Frank rule requiring companies to disclose certain payments to U.S. and foreign governments. There will be a number of other CRA resolutions that originated in the House that the Senate will take up this year. We will see which ones pass, but as a friend of mine pointed out on my way in here, we will know by the end of this Congress, we will increase the use of the Congressional Review Act by something like 1,000 or 1,500%. And 10 years from now, the courts will consider for the first time what counts as a substantially similar regulation to something that had been invalidated. There will be a whole marvelous growth of case law for administrative law professors to write about, all because of the happenstance that we now have unified Republican control of the government following a Democratic administration. So one solution to this, as the panel will talk about, is to kind of reverse the default presumption, which is what the Reins Act attempts to do by establishing a different procedure by which, when an agency attempts to promulgate a major rule having really significant economic effects on the economy, that rule cannot take effect until first Congress enacts a law authorizing that regulation. The panel, I think all of us are going to discuss some of the both constitutional and policy-based critiques and justifications for that law, but I think it's important to notice that the idea, going back to the way I like to think of it, is that solves, in a way, a legitimacy problem with agency action if it works, right? Which is that if major agency action having enormous effects on the economy is legitimate only if Congress can control it, and under our current system, Congress seems unable to control agency action, then the Reins Act is a way of enabling greater congressional control by requiring congressional permission for really important policy decisions that, you know, if you were a member of the Article I project, I'm sure Senator Lee would tell you in his keynote address, are things that Congress really ought to be doing in the first place. The objection to that, which I think is a real one, is even CRA Reins Act resolutions require floor time. And floor time they don't require that much, but they do require time on the floor. And time on the floor of the Senate is probably the joke around here is that it's the most valuable commodity in the world, because the majority leader is, you know, like, if he's good, and he is, and so was his predecessor, is the best time management game clock manager around. The job is to get the president's executive nominees confirmed, judges confirmed, important legislation passed, the government funded. All of that takes days on the floor. So the question is, how much time are we going to devote to authorizing major policy initiatives by regulatory agencies? Don't know. That's a tricky question, and I want to leave everyone with the following question, inspired by, I think, the current political atmosphere, which may not last forever. But at the moment, it is the view of Republican Senate staffers like me, but I think also it's objectively true, that the Senate floor is being ground to a slow halt as the minority can make it, right? Even on what you might think of as non-controversial nominees, floor time is being expended to require the majority to spend as much time as possible confirming nominees, which means that it may be that the premise of the Reins Act, which is that the Senate floor will be available to authorize really important legislation, even necessary legislation to authorize necessary rulemakings, may not in the end be true. Finally, I think it's important to remember that in the new era, right? That is when you have following 8 years of Democratic administration, you will have at least 4 and maybe 8 years of Republican administration. The need for congressional control of administrative agencies, we may all exchange talking points with each other after the election on this issue like everything else. Suddenly, you might want, if you're a Democrat or if you're left of center, and you think you're going to win a midterm election in 2018 and throw the president's party out of office based on how much you don't like him, you would then want the new Congress to be able to do something to control his agenda in the same way that Republicans wanted to be able to do something to be able to control President Obama's agenda. And so it may be that it's not so much a partisan left-right issue about whether we should have some kind of rule like the Reins Act or not, as it may have seemed to everyone before the last election. Thanks.
Thank you. Now I'll go. But I want to begin thanking, of course, my hosts, ABA and the Scalia Law School, especially since my daughter just accepted admission. I long ago lost influence on her, most of my influence on her education, but Naomi and her colleagues will take over. I was privileged to be the chief counsel for the House sponsor when CRA was negotiated, and he's always been very kind to publicly out my role in helping the drafting, and so that's what spurred my scholarship in the area. And I was one of these whiny guys that kept saying, but it really requires the agencies to send more than just notice and comment, Federal Register rules up. No one listened to me, but in my presentation, I'm going to relate some consequences for the agencies that are now beginning to get recognition, and I'll take a minor exception to one or two things Matt said about how the Congressional Review Act operates now and can operate in the future. So let me begin by just pointing out that the fulcrum and the powerhouse of the Congressional Review Act, the only thing that makes it work at all is its first sentence. And the first sentence of the Act, which is repeated later in the Act, says that before a rule can take effect, the federal agency promulgating such rule shall submit to each House of the Congress and the Comptroller General a report containing, and then a copy of the rule, concise general statement relating to the rule, proposed effective date, and then they've got to supply some additional information to the Comptroller General. Now, the reason that is both the fulcrum and the powerhouse of the Act is that Congress needed a date certain on which expedited procedures would apply for these resolutions of disapproval, so that there was a clear beginning date and end date. The other purpose, of course, was because publication alone would not create that date. Paul Larkin is in a couple tables back, and he's written a brilliant paper. All of his papers are brilliant, but this one is on some aspects of what a further reach back provision of the CRA for agencies that never submitted rules that were required. And so Paul goes through some of the other reasons why, but I can tell you one other reason that's in the legislative history for the Act is there's a term Clyde Wayne Cruz calls for guidance documents and policy manuals, regulatory dark matter. It was always the intent of the sponsors, even for those things that were not required to be published in the Federal Register, that they be submitted to Congress so that scholars and GAO and CRS and anyone else could begin to get a better handle of those documents. And the second point I wanted to make is that rules in the Act borrowed a term slightly modified from Chapter 5 of the APA, is the broadest definition of a rule in the APA. It includes almost every general statement of future of agency policy and future effect, not particular application, but of general application. And then there's a few hunting and fishing licenses; those were exempted. We don't want to stop hunting and fishing season. With a few minor other exceptions dealing with monetary policy and a few other things, everything must be submitted to Congress. So that was a second reason why publication alone was not sufficient to trigger the Congressional Review Act, because a lot of these types of documents are not required to be submitted for publication in the Federal Register. Well, 21 years later almost from the passage of that act, there have been various studies showing that there were hundreds and hundreds per year of rules, even that were required to be, that were published in the Federal Register, never delivered to Congress. Most of them are trivial, but many of them are significant, or only OMB classifies them as major, but I can tell you that many are. Well, since I've been talking about the consequences of this, my colleagues at various institutions who are cooperating on a project that, if we could get the computer to work, I would show you, is a new website called write it down, redtaperollback.com, redtaperollback.com. CEI, Heritage, the Club for Growth, and a few others are already partnering with us. We're finding, especially the policy manuals that bedevil our clients at the Pacific Legal Foundation, some that double the size of the Clean Water Act jurisdiction, are examples of policy guidance that was not published in the Federal Register, but has more significance than most of the things published in the Federal Register, was never submitted to Congress. I'll give one quick example, since the President a couple days ago ordered Pruitt and the Army Corps of Engineers to re-examine the WOTUS rule in light of the Rapanos case, which Pacific Legal Foundation won. So a straight repeal would do almost nothing. The reason the straight repeal would do almost nothing is because the underlying guidance the agencies have been using that is wrongly being enforced against our client is the Rapanos guidance, never submitted to Congress. So we've been arguing that it's illegal because it doesn't follow the Rapanos case, and that's certainly right, but at least the agencies can argue against that, and they can tweak and make Kennedy's solo concurrence even worse. So they can illegally do that, but they can get away with that. But it was never submitted to Congress. So what's the consequence of that? So the consequence of that is what we call CRA 2.0, and then I'll get quickly to CRA 3.0. CRA 2.0 is what could happen for all those hundreds, there are certainly thousands that were never submitted to Congress, but the hundreds that were terribly significant. And one consequence, of course, is that they were never in effect. The administration needs to drop all enforcement action. So this is a major, I would say, tsunami in administrative law. And I've had, since this was Kimberly Strassel published an article in the Wall Street Journal yesterday, editorialized on this as well yesterday, and I've happily been fielding hundreds of calls from lawyers who, looking at the text, say that's absolutely right. Okay, well, what's the rest of CRA 2.0? That means that there are any rule, however broadly defined, to include these policy manuals, major guidance documents, and some notice and comment rules we found already, can be submitted by the Trump administration now, even if they're 21 years old or almost 21 years old. And there is no doubt, as Paul Larkin has definitively shown, that the clock never started to tick for those rules under the Congressional Review Act. There's three textual ways to get there, but this is really, I think, beyond any serious doubt. Congress could not have introduced a resolution of disapproval that is triggered by the submission to Congress. It all, as I said, there's three textual reasons for this. And I think it's without a doubt that the expedited procedures then exist for 60 session days in the Senate, 60 legislative days in the House for a resolution of disapproval for these rules. And that's true whether there were notice and comment rules, too. If there were notice and comment rules passed 8 years ago, but never sent to Congress, they've been unlawfully enforced, they should be submitted. And if the Trump administration wants to submit them, what I recommend and what the website recommends certainly is an orderly review process in the administration. And certainly the administration should focus on the most economically significant. And then they should, and the most recent in time. But they could send hundreds up to Congress with the recommendation to go into effect, which was the presumption always from past administrations, but might not be. And then they could submit maybe 3 or 4 a year, or 3 or 4 a month, I should say, that they want a resolution of disapproval so that nothing like that could be substantially enacted again. And I got my 1-minute notice, so with the 30 seconds left, I will just say that there's 2 other options. The administration can decide not to announce in the Federal Register that these rules never went into effect. I think they have to drop all enforcement action. And for the notice and comment rules, the law is a little unclear, but I think they can certainly go into an interim final rule while they've announced it was not in effect and not being enforced, and seek comment on whether they should be modified or withdrawn. But the presumption, because they were always illegal, is that in the interim, regardless of what the administration does, those rules are not enforced. So thank you.
Great. Well, thanks. It's a pleasure to be here. I want to turn from the discussion of the Congressional Review Act to the Reins Act and how that is, I guess in some respects, a sequel to the Congressional Review Act and how it seeks to overcome, I think, some of the deficiencies of the Congressional Review Act, but is ultimately designed to address what is at heart the same underlying problem. And so let me say a little bit about what that problem is, or that problem as I conceive of it, and how the Reins Act seeks to address it, and why I think it's the sort of reform proposal that makes sense. So the underlying problem is that agencies exercise delegated power. We don't, for all practical purposes, have any meaningful type of non-delegation doctrine. There may or may not be good reasons for that. That's a debate for another day. But the reality is Congress delegates broad swaths of what is effectively legislative power. We don't call it legislative power. We call it quasi-legislative power. But the power to create rules binding on private conduct. Congress delegates this power to agencies, and in practice has somewhat of a difficult time ensuring that that power is exercised consistent with the ongoing preferences and desires of the legislative branch. The legislative branch is the source of this power, but for all sorts of reasons, it is hard for the legislative branch to modify that grant once it's been given, and with the exception of, for example, a handful of particularly influential committee chairmen, it is difficult for the legislature to exercise significant influence on the way that power is used on an ongoing basis. And so what the Reins Act ultimately is about, at least in my view, is creating a mechanism to ensure, at least with the larger decisions, the decisions of the greatest magnitude, that agencies are more attentive to the preferences of the current Congress, and that Congress has an easier time disciplining or constraining agencies when agencies go beyond what Congress would have wanted or deviate from what Congress's preferences are. And if you want to think about this kind of in principal agent terms, unfortunately this means we have to use agency we have to talk about agencies or as agents. If you think about Congress as the board of a large corporation, or board of a large entity, clearly Congress doesn't want to have its hands in every single decision that its agents have to make on its behalf. They can't monitor each and everything that each official and each subsidiary does on an ongoing basis. But certainly we expect the governing body to pay some attention to those decisions of the greatest magnitude, those decisions that have a dramatic effect on the overall operations of the entity. And so creating a mechanism whereby those decisions of the greatest magnitude, major rules, are subjected to a different type of congressional oversight, are more easily overruled or rejected by the legislature, which is the principle in this relationship, is a way of ensuring that the big decisions are made consistent with the desires of the legislature without trying to insert the legislature into the everyday operations that the agencies. And this makes sense because Congress delegates power to agencies because Congress doesn't have the time, the resources, the expertise, the desire to be involved with every little operational decision that is made in all the different federal agencies. But Congress does care about the particularly big decisions, and Congress certainly cares about them in the aggregate. And another thing that adds to this problem is that because Congress does not on a regular or routine basis enact authorizing legislation that gives agencies power to enact rules and to take other actions, that defines the contours of that power. This is something that Congress does relatively infrequently. And again, we can have a separate discussion about why that is, but as a practical matter, we know that Congress tends to grant large amounts of power to federal agencies at a given point in time, and then lets it go, right? So the last time the Clean Air Act was significantly modified was 1990. 27 years ago. Today we have quite a few live controversies about actions that the Environmental Protection Agency has taken under authority that in some cases was originally granted in 1970 or 1977 and hasn't been meaningfully modified since 1990. And there's no reason to assume that the legislature today, the legislature that currently represents the view of the American people, that currently is exercising the legislative power provided by the Congress, by the Constitution, necessarily agrees with the view that Congress had 27 years ago when it delegated that authority. And moreover, the Congress that delegated that authority 27 years ago was thinking about very different sorts of things with regard to air pollution and so on than Congress might today and the EPA might today. And so there is this temporal problem that is a result of delegation, where agencies are often exercising power that was delegated to them by not only a Congress that had different preferences, but a Congress that had different knowledge, different understanding, different priorities. And I use the Clean Air Act as an example, but we could talk about the Telecommunications Act. We could talk about any number of these statutes that are the primary sources of federal regulatory authority in various agencies, and we tend to see a similar phenomenon. A statute gets enacted, Congress rarely revisits that for a long time. Okay, so what would the Reins Act do? The Reins Act would say that for major rules, those rules that the language in the version that passed the House says that have costs estimated by OMB to be in excess of $100 million or otherwise have large economic effects, could not become effective unless they are approved by Congress, by a joint resolution that passes both the House and the Senate and is signed into law by the President. In effect, what this does is it says, even though we're using the language of rules, it turns major rules not into rules but into recommendations. They are proposals. Proposals to Congress informed by agency expertise that Congress must ultimately approve. And this is a way of enacting policy that we can certainly imagine that Congress might want to do all the time, right? Congress knows, look, we don't know a lot about air pollution. We know it's a problem. We know air pollution control is expensive. We know there are difficult trade-offs on the margin. We want help figuring out how to manage those trade-offs and how to do that, and so we'd like a proposal. And Congress might also recognize that, you know, if the proposal comes to us and then we go through our normal legislative process, well, it's too easy to bottle it up. It's too easy to evade responsibility for making this decision. Maybe we want to, as we do with things like base closings, as we do with things like Trade Promotion Authority, bind our hands and say to the agency, you give us your proposal and we will commit to voting for it up or down. And that is what the Reins Act does. It creates an expedited process whereby major rules are submitted to the House and Senate, privileges the resolutions to affirm those major regulations, and forces the legislature to vote up or down. And in my view, this does two things that are very important. One, as I already mentioned, it ensures that the exercise of legislative authority is done in a way that is more consistent with the preferences, desires of the current Congress. I think it also provides the added value of forcing members of Congress to actually vote up or down on the major regulatory questions that are facing the country. If you're like me, you go home and you see letters in the paper from, say, your home state senator, not the one that's represented here, my other one, that says that what the agency is doing is terrible and they should do something else, but not saying if the only choice was to approve or reject a particular proposal, what that senator would do. And that's a problem. That erodes accountability. That makes it harder for the people to, through the legislature, make sure we have the sort of regulatory policy that we want. I know my time is running out, so let me just say a couple quick, I'm sure the constitutional questions about the Reins Act will come up. Let me just say now, I don't find any of those constitutional arguments particularly compelling. I've written about it, happy to answer questions about that as well. So in terms of practical effects, I think there are a couple practical effects that are worth highlighting. One is that this will affect agency behavior. Agencies will no longer be saying simply, what can we get away with in the courts? Agencies will be saying, how do we adopt a rule that is faithful to the delegation of power that we were given as understood by the principle that delegated that power? And that's important because agencies don't get their power from the president. They get their power from the legislature. And so in terms of our constitutional structure, they should exercise that power in the first instance consistent with what Congress should want. If we don't like what that might look like substantively, well, then it's our job as citizens to do something about Congress. But in terms of our constitutional structure, that's the way it should operate, and the Reins Act would help with that. Another practical effect I should just note is that I do think, and I know the sponsors of the Reins Act are not sure they like this, and we can discuss as well. I do think another practical effect is it would, whether the Reins Act says this or not, alter the way courts review agency actions. And I actually don't think that's a problem. I think as a general matter, one of the reasons courts engage in the sort of hard look review of agency action that they do is because they are looking at the actions of the agent, not the actions of the principal. And I think if the principal reasserts itself, there are good reasons why that would alter the way courts look at agency actions. And that might also reduce some of the uncertainty that we get from judicial review of agency action. And I think that would also be a good thing, a good consequence in terms of our overall system. I will stop there because otherwise Naomi will throw water at me or something.
Yes,
so thank you.
Over your time. Okay, Jonathan Seaholt, thanks.
Thank you, Naomi. Thanks for inviting me. It's an honor to be on this panel, and I'm really excited to address an audience that includes people who will actually be making policy on these important issues. So like Jonathan Adler, my topic is the Reins Act. There are two big questions about the Reins Act. First, is it constitutional? And second, is it a good idea? On the constitutional question, the short answer is yes, it's constitutional, but it does have some vulnerabilities based on the way it's written. I think if you are a supporter of the Reins Act here today, if you're trying to get it enacted, you might want to consider tweaking the language a little, leaving the substance unchanged, not changing what the Act does, but changing a little of what it says in a way that might make it more secure against constitutional challenge. Why do I say this? Well, the simple reason that the Act is constitutional, as already indicated by Professor Adler, is that, all the Act does is it takes from agencies a power that Congress never had to give them in the first place. Congress never had to give agencies the power to make rules. Congress chose to give that power, but it can take it back. It can say, as Professor Adler put it, instead of making rules, you shall henceforth make proposals. And so that's constitutional. And that's what the Act does. But that isn't what the Act says. The Act does not say we take from agencies their rulemaking power and instead authorize them to make proposals. The Act says agencies may continue to make rules, but those rules have to be approved by Congress. And that's what gives rise to this argument that the Act violates the rule of INS versus Chadha in that it allows either House of Congress acting by itself to kill an agency rule. Now, that argument is incorrect. I mean, under the Reins Act, a House of Congress would not kill an agency rule. The rule would simply not be effective to start with under the Reins Act until an act of Congress empowered the rule. So the Chadha argument is incorrect, but the form of the Act, the language of the Act, gives some slight color to it. So I think proponents of the Act would be better off if they changed the language so that the Act would expressly say that which it actually does. Instead of saying agencies can make rules but Congress has to approve them, it would be better if the Act said, from a constitutional perspective, it would be better if the Act said agencies cannot make major rules, they can only make proposals, and Congress can approve them or not. And if you ask, who could care about that? Who could care about whether the Act uses the term rules or proposals? All I can say is sometimes courts get caught up in these little points of nomenclature. Look at what happened to the Line Item Veto Act. It said the president can cancel spending items. Supreme Court said that was unconstitutional. I thought Justice Scalia was right in his dissent when he said if the Act had only said the president can decline to spend appropriated funds, everyone would agree it's constitutional. Even though those two are functionally equivalent, the Supreme Court struck it down. So sometimes these nomenclature things matter, and I think the Act would be more constitutionally secure with somewhat different language, although to be clear, I think it's constitutional as it's written. Then the other big question is whether the Act is a good idea, and I have to say I think it's not a good idea, and Congress should not enact it. There is obviously one very good thing about the Reins Act, which Jonathan brought out, which is it would reclaim Congress's role in the making of social policy. If you start with the basic, constitutional idea that Congress is supposed to make the laws and the executive branch is supposed to execute them, obviously we have drifted quite far from that ideal. As over a period of decades, Congress has delegated enormous discretion to the executive to make social policy. So this would bring us back to Congress's involvement in the making of social policy. So that would be a good thing. But I think it would be outweighed by the problems that the Reins Act would create. And to see what those problems are, you need only ask yourself why Congress delegated so much power to the executive in the first place. And the answers are time, expertise, and politics. On time alone, if you just run the numbers, if you just divide the number of days the Houses of Congress are in session during a typical Congress by the number of major rules that come out during a typical Congress, you see that if the Reins Act passes, Congress is going to be dealing with approval resolutions under the Act, on average, about twice a week. That's a lot of time, and as Matt pointed out, it's going to eat up precious floor time. And these are major rules. By definition, they're major things that would require time and study to vote on responsibly. I just don't see how Congress is going to have time to vote responsibly on major rules twice a week on average. Expertise. Congress delegates matters to agencies because they want certain matters to be decided by expert decision makers. Agencies develop expertise in their particular subjects. A lot of these rules are highly technical, and I don't think Congress is going to have the expertise to vote on them again, especially twice a week. And then finally, and this was presaged by something Matt said, just look at the politics of the situation, and particularly the gridlock that could ensue if the Reins Act were to pass. I mean, one might imagine it working out not so disastrously in a period of unified government such as we have now. But what's going to happen? What's going to happen if Congress passes the Reins Act and the Democrats were to recapture even one of the two houses of Congress in 2018, and suddenly no major rule can be passed by any federal agency without the approval of at least some congressional Democrats? I think Republicans would then regret having passed the act. I mean, I'm impressed that the House moved forward with it in this Congress. It shows good devotion to principle. But as Matt said, perhaps there's some rethinking of principles. Perhaps it's less a left-right matter than an in-out matter, that if you're in controlling the executive, maybe you don't like the Reins Act so much as previously. My time is running short. Well, let me just conclude by saying that I understand and appreciate the desire of Congress to reclaim more of a role in the making of social policy, but I just don't think the Reins Act is a good means of achieving that goal.
Great. Thank you very much. Thanks to all of our panelists. So we have some time now for discussion amongst the panelists, and then we'll open it up to questions. I guess I'll start with a question for Todd. Todd, I was wondering if you could say a little bit about judicial review of rules under the CRA. If those rules are not effective and they're not valid, then can courts frustrate?
That's an especially good question, because probably people in this audience know, educated, that there's a limitation on judicial review in Section 805. And I call it a limitation. Others may call it a complete ban. The majority of lower courts have found it to be a complete ban, but usually in very superficial decisions. There is a split. The lower courts that have considered it a little bit more thoroughly have followed consistent with the legislative history that says that the bar it's an oddly worded bar, but that Congress didn't want its determinations under the Act or the President's, OMB's major rule. And my memory isn't worth anything in court, but it was negotiated with the administration. This was something that Clinton signed and agreed to sign, but also members didn't want the major rules were upheld in their, or were extended in their effectiveness by an extra 30 days from the APA, and we didn't want litigation. They didn't want litigation over that. But to give effect to whether if it's undisputed that the agencies never submitted anything, then the court isn't passing on a determination. It is giving legal effect to the absence. And I think the courts that have been a little bit more thoughtful have whether they relied on the legislative history or not, have found that to be persuasive. I'll defer again to Paul Larkin, who made a very persuasive argument that those of us who would be using it defensively would be raising a due process claim, and we would say that there's no due process of law if there's no law, and that's a constitutional claim that Congress, the canons of construction say, must explicitly bar, even if the courts would give that effect, and of course there's no explicit bar on due process claims. The final thing I'd say is we won 2 out of 3 of our recent Supreme Court cases unanimously, that the lower courts, they were APA Chapter 5 judicial review cases, Sackett and then Hawks last spring. And in Sackett case, 8 district courts, and the fly loves me, but 9 district courts said there was no judicial review. Every circuit court of appeals said there was no judicial review. there was no circuit split, but we had an outrageous enough application, the Supreme Court, take it 9-0 reversal. So lower courts read judicial review bars broadly because they don't like cases in their courts. The Supreme Court reminds them that the APA judicial review is to be broadly or strongly presumed. This is an actual bar, so that arguably gets over the strong presumption. But I think the courts I'm very confident that even Kagan and Breyer and Ginsburg would find the defensive use to be subject to judicial review.
Great. I have another question maybe for Jonathan Adler and Matt. Both of you talked about the fact that the legitimacy of rules in part comes from accountability to Congress. Of course, the traditional account in Chevron and other cases is that these rules are valid because of accountability to the president. So I'm wondering if you could say a little bit about something about that. And also, so Jonathan, you also mentioned that there should be accountability to the delegation that was given by Congress. But of course, Reins updates things to the modern Congress. So how do you reconcile those aspects of accountability to Congress at different times?
Sure. So on the first part of your question, I think it's right. The traditional Chevron account is that judicial deference to sort of agency policy making through interpreting federal law is justified in part because, at least as between the court and an agency's basically political judgment and policy-based decisions about how ambiguity should be resolved is more legitimate than a court doing it using canons of construction because the agency is accountable to the president. What we are talking about here is a different sort of interbranch dispute. We're talking about whether Congress or the president should ultimately be responsible for what is basically lawmaking. I think Jonathan is right about that. I don't think anyone really disputes that. And what we are talking about is an authorization from Congress for agencies to write prospectively and generally applicable rules of conduct that are subject to sometimes criminal penalties and civil penalties. And so what we're talking about is lawmaking, and I think that we don't need to get into whether the non-delegation doctrine should be revived or not, but whatever you think about that, if Congress has authorized agencies to engage in what is basically lawmaking, in our constitutional structure, the legislative power is vested in the Congress, not in the president. And if Congress wants to give it to an agency, their ability to continue to use that power has to somehow be subject to the control of the legislature, or else we've really gone far from the sort of constitutional structure that's supposed to legitimize the whole enterprise.
I agree with that 100%. I would add one additional thing is that, Chevron, when it was first decided and, in the first 10 or 15 years afterwards, there was some debate about conceptually how we understand what the underlying basis of the doctrine is. And what the Supreme Court has settled on in cases like Christensen and Meade and so on, which I think are correct, is that the entire basis of Chevron is a presumption, perhaps a legal fiction, but a presumption that the power that the agency is exercising was actually delegated by Congress. So the assumption that the agency is more accountable than the court is true. I think it's one reason why we might like Chevron, but it's under existing doctrine premised on the idea that the agency was given that power by Congress, and so it is exercising of delegated power. So I think it's entirely consistent with this framework. There are some folks that don't like that conception of Chevron or don't like the implications of that conception of Chevron. That's a debate we can have, but I think under Meade and related cases, there's no question that the current court has said that that is how we should understand Chevron, and I think that's why it's appropriate to prefer the agency over the court in certain circumstances, but that says nothing about the legislature versus the agency. On the issue, on the temporal question, I think it's useful, I think, to think about this in principal agent terms. And I know it's not fashionable to think about public law questions, but by reference to their private law analogs. But I actually think that helps us understand the way we should think about the relationship. It's not that the Congress of 1990 has some talismanic power that means the 1990 Clean Air Act amendments should forever and always be understood solely with reference to that Congress. Perhaps that's how we understand that text. And that's a clue to the semantic meaning of the text that was enacted in 1990. But the principle that is the source of that power is the current Congress. And if the current Congress decides that rather than reopen the Clean Air Act every 2 years or every 5 years or after every time there's a change in majority, to instead say, EPA, you can keep going on doing what you've been doing, but if you're going to make the really big decision, you're going to have to come back to us. That's a perfectly reasonable, understandable way for the current principal to modify or constrain the behavior of its agent. And it's the sort of thing we, again, in the private law analog of a principal-agent relationship, we would think is completely unremarkable. In fact, in some contexts, we would say it is completely irresponsible for the new board of a corporation to not create some mechanism to make sure that power that was delegated previously is not exercised in a way, at least with regard to the really big questions, that is consistent with the contemporary principles understanding. And I view the Reins Act as trying to accomplish that. I agree with Jonathan that there may be ways in which the text could be tweaked or fixed or made even better, but that's what I see it doing, and I don't think that should really be objectionable unless our assumption is we just prefer agencies to Congress because they're insulated, because they're not accountable, because it's hard to control what they do, and for whatever reason we just like that better. I happen to think that constitutionally that's a very problematic view, even though I know that politically it does have its adherents.
Jonathan, did you have any response to that?
Well, one comment that occurred to me as Jonathan was speaking is that, if there were something clear in a statute passed in 1990 that the agency was just implementing, it wasn't a question of making a rule about it or interpreting it, they were just implementing what the statute said, and the current Congress didn't like it, the agency is still bound by the 1990 law until the current Congress changes it. So you make a good point, Jonathan, with your principal agent analogy, but one thing that at least needs to be considered is that here the principal has this important procedural constraint on the way in which it can change the instructions to the agent. The board of directors presumably can at any time change its instructions to the corporate officers, but our Congress cannot change the instructions to the agencies except by going through some stringent procedures.
Although they do things like, say, for example, appropriations riders that prevent agencies from fulfilling what are clear legal obligations enacted in prior statutes, precisely because they have the votes to get something on as a rider on an appropriations bill, and they don't have the votes to make a substantive change in the authorizing statute. My argument would be that something like the Reins Act is actually a more forthright way of modifying the pre-existing authority. Rather than burying something in an appropriations bill that half the members of Congress won't have read or thought about, it'd be much better to say, okay, yeah, in 1990 we told the EPA, we expect you to do X. EPA has done that. Now maybe we disagree, and rather than kind of some surreptitious way of preventing the EPA from doing it, we should actually have to vote up or down on whether or not we want to do it. And again, from a standpoint of just democracy, that's great. And I will say up front, people think the Reins Act is solely about stopping regulation. I'm not convinced that's the practical effect, right? I'm not convinced that the public's preferences for regulation in certain contexts necessarily matches that of the legislative majority. And I think that forcing Congress to vote on these things on a more regular basis would actually help us discover that, right? If the public's preference is for greater regulation of consumer protection, the best way to find that is to make members of Congress take those votes on the record and have to defend that when they run for re-election. The current system makes it very easy to obscure that degree of accountability, and so we don't know whether or not what regulatory agencies are doing is more or less than what the public would actually want.
I have to agree that would be a good thing about the Reins Act. Although I would just also point out, as we learned last November, the regulatory agencies are not completely insulated. You can change them by changing the president, and that's what the American people did. There's been a lot of changes at the agencies because of what happened in November.
Thank you. So I'm happy to open it up now for questions. We have some microphones coming around, so if you could just keep your hand up and wait for a microphone. Okay. If you could just introduce yourself.
Hi, my name is Danny Fischler. Thank you all for your really interesting remarks. I had a couple of questions related to two provisions in this instance of the Reins Act that haven't been discussed on the panel yet. I think there's sections 808 and 809 of HR 26. 808 is a regulatory cut-go requirement that applies to all new rules, such that they wouldn't be able to take effect without offsetting the costs of those rules. Obviously, when you combine that with something like the Regulatory Accountability Act's focus on indirect costs, that could be an interesting provision to think about. And there are no exceptions in there for like good cause, that sort of thing. So I was interested in your thoughts on that and on 809, which appears to require agencies to inventory all of their rules, or if we take Mr. Gaziano's view, all of their rules plus all of their guidance documents, and then on an annual basis submit 10% of their rules, however you measure that, to Congress for an up or down vote. And if the Congress doesn't vote them forward, the rule is sunset. So I was wondering if the panel had any thoughts on those two provisions.
I'll start. In principle, I like sunset provisions. I also have this odd view that if the authorization of a statute expires, then the statute itself should actually expire. Now, we clearly don't do that, but I think that would be preferable. So I like the idea of some kind of sunset provision. I'm not entirely comfortable with the language of Section 809 as it passed the House. I think if you want to have a sunset provision, it'd be worth fleshing out precisely how that's going to work and in a little more detail. Similarly, the 808, Section 808 cut-go requirement, in principle, the idea that we might think of, have some kind of regulatory budget or conceive of regulatory costs as something that have a level that we don't want to exceed, and that we should, if we're adopting new regulations that we think have a certain volume of benefits, we should be identifying regulations that have fewer benefits so our costs stay constant, our benefits go up. Again, in principle, I like that idea. I think the one paragraph that is Section 808 begs a lot of questions about how it's going to operate and how it's going to be enforced. Now, maybe an OMB guidance could handle some of that, but if I were looking at a version of this to pass in the Senate, I would probably spend some time on those provisions to try and give them a little more detail and answer some of the implicit questions about precisely how they would operate.
And I'll just throw in, doesn't Section 808 essentially duplicate what President Trump put in one of his early executive orders? So we're going to find out his order that's mostly known for the 1 in, 2 out requirement, that for every rule an agency adopts, it has to identify 2 rules for elimination. Also, I believe, has a requirement, maybe not on a rule-by-rule basis, but I believe it says the agency is required to ensure on an annual basis that it imposes no new net costs. So we're going to see how this works. I would like to see something about the benefits of the rule in there, too. I think considering only costs is not the best way to do it, but we'll see how it works out.
Thank you.
So,
You got it.
so Dick, I beat you to the mic.
Okay.
I'm Susan Dudley from the GW Regulatory Study Center, and my question is also on Reins, so it's to the two Jonathans. Does it apply to major deregulatory actions as well as regulatory?
The short answer is yes.
Yeah, I mean, the language in the versions of it has been different in different versions. The current version says costs rather than effects. If it were up to me, it would say effects rather than costs. And I think in part because the underlying principle should be that we want the legislature to approve things of a given magnitude. And but even though the language says costs, and it also talks about other effects, and presumably benefits aren't coming out of nowhere. So if you're talking about rules of major magnitude, I would assume they would be covered. But if it were up to me, the definition of major rule in the Reins Act would reference effects, not costs, and that I believe would then also perfectly mirror the standard that the OMB already uses for major rules, which I also think would be wise to do, because to have a major rule for one statute but not for another, and for one that's just asking for trouble. It'd be having a standardized understanding of what constitutes a major rule, I think just makes more sense generally too.
We got a question up here.
Dick Pierce at George Washington Law School. I had a practical question for Todd. Suppose I'm running a regulatory agency in the Trump administration, and I look at one of these many rules that was never submitted and issued over the last, I don't know, maybe it was issued 7 years ago or so. It's not one of the relatively rare ones that was issued through notice and comment. So I look at it and I say, I really don't like this at all. I can repeal it with literally the stroke of a pen. Why shouldn't I just do that instead of going through this convoluted process of submitting the rule I disagree with to Congress, thereby requiring Congress to devote a bunch of time to getting rid of a rule that I can eliminate with the stroke of a pen?
Good question, and for most such rules, you probably wouldn't submit them to Congress, as your question implies, but I'll tell you a few reasons you might. First of all, though, the non-premise of your question is it's especially valuable, I think, if you have a notice and comment rule, and there are some we found. Most of those were submitted to Congress, and the time has expired, even outside the midnight rules provision. So you might want to get Congress's help. But the other reason on the guidance documents, policy manuals and things like that, is A, it shares the political responsibility. After all, the Congressional Review Act, I think it was one of the President's chief strategists that said the third pillar of the administration is deconstructing the administrative state. So hopefully he would be for sharing that political accountability. But more importantly, on certain rules, it would have two more significant effects. One is that if it's the type that there is a majority to overrule, it has the additional bar that the agency that you run could never issue a substantially similar rule. So you're doing something great for America if it's getting rid of a terrible rule that you don't want to come back in another administration. But third, and I think this might be the more practical one, and that is it changes the bureaucratic dynamic enormously. Yes, you can get rid of a supplement to the wetlands manual, the Alaska supplement that was illegal, that was never submitted. But you're going to have to replace it probably with something, and you're going to have to fight your own bureaucracy on that. If Congress has already rejected it, then their hands are legally tied, and it changes the bureaucratic structure. But back to the original. I think for most guidance documents, what we call CRA 3.0 is the President admitting it was never in effect, and that also strengthens the agency head's hand, and simply saying it's withdrawn, it's being reconsidered, whatever.
Thanks. Question? Yeah? Yes?
Yes, this is Raphael Madden. Two quick comments, if I may, or maybe thoughts. One is to the suggestion Congress doesn't have time to do certain things. I certainly appreciate that. I was up here myself several years ago. But we all know that when state legislatures went to full-time, the amount of legislation produced increased. Whether that's a good thing or a bad thing, I suppose, is a good debate. So perhaps that Congress wouldn't have time, and therefore these things wouldn't go into place, might be a feature, not necessarily a bug. But the other thing I was thinking is, I think there isn't just one overarching problem, and that is the delegation, non-delegation problem from Congress to the executive branch. I think there's also the questions relating to the president himself. Rules are often very difficult to undo. It takes years, and what you do is you essentially give, this is the reason they have midnight regulations. It takes the new administration several years to get to where it might want to be, and so what you've done is you've given the former president another 2 or 3 years of his term. It has the whiff of unconstitutionality about it. Perhaps some mechanism, either confined to the midnight rules or maybe not, but some mechanism that says that a president can undo any particular rulemaking action, and what it does is it restores the status quo ante. And it can be done very quickly, and there you are. Now, maybe the president doesn't like that one. We might like it better. There's, I think, that many difficulties as to what happens if you lose one house, if you don't have a full control of the government. Many of those things would go away if presidents were given their full authority, if they're supposed to execute. And what you have now is administrations having to execute rules or deal with rules that they themselves don't believe to be particularly faithful expostulations of the law. You got a problem.
Thank you. Does anyone respond to that? Or?
Sure, I will say that I guess I agree that there are easier ways to solve the midnight rules problem. There are bills under consideration that would do that. Someone mentioned the Regulatory Accountability Act, which does a number of things. That is one of them, but there are also some sort of standalone legislation proposals that I think our committee will consider this year to empower an incoming president to cancel or suspend, or send out for re-notice and comment for new proposals, midnight regulations enacted or made effective in the last, so many days of an outgoing administration. And that would be a more efficient solution to the midnight rules problem. I think Todd has identified a way of using the CRA almost as a one-off, right? Once you fix the sending all your rules to Congress problem, you can't use it in this 2.0 or 3.0 way in the future, but once you notice the problem, you can reach back and use it as a sort of a patchwork solution. But it's not, I think a lot of what Todd says is right, but it's not a 70-year plan for reining in executive action. It's maybe like a 3-year plan for reining in executive action right now, right? Meanwhile, I think the broader problem that Jonathan and I both were talking about before, about the need to do something about the fact that agencies are exercising delegated authority, does require something broader than just a midnight rules bill, some mechanism to enable Congress to control the way agencies behave. So just to pitch something of our own, Senator Portman is the Senate's lead sponsor of the Regulatory Accountability Act, which is not up for discussion today exactly, but I do think it's worth putting a little note in everyone's mind about it. That bill, the idea is to rewrite the way the APA requires agencies to engage in rulemaking, particularly for major rules having a $100 million effect on the economy, or for what we call high-impact rules having about $1 billion effect, which would require agencies to engage in sort of more rigorous upfront consideration of costs, benefits, science, et cetera, and sometimes to engage in more formalized adversarial proceedings. The idea being that if you can't make Congress consider these rules itself, at least Congress can control the way in which agencies are going to engage in this kind of rulemaking and make it, and so maybe the agency would rather Congress just decide it ourselves, but if not, at least there's some Article I control of the way in which this thing that the administrative state is doing is going to be done, rather than it merely being a matter of the President's OIRA guidance to decide how agencies are going to go about engaging in cost-benefit analysis or similar kinds of studies.
Thank you. I think there was another question, right?
Yes, hello, Björn Arp. My name from American University. I have 2 quick questions. First of all, your thoughts on the threshold in the Reins Act, which I think is set at $100 million for regulatory impact or action. I would think, at least, that this threshold really is also a clear sign of the objective that the law tries to pursue. And I may think that 100 million is a relatively low threshold. And you were saying yourself that it is foreseen that there will be a lot of voting going on in the Congress if the Reins Act is adopted. And maybe by raising the sort of threshold, the really more important issues may be assumed by the Congress rather than having to micromanage practically everything that goes on in this country, keeping in mind that we are here on the federal level, not at the state level. And my second question is, has to do with the with the normative aspect of all this, because if the Reins Act distinguishes between major rules and not major rules, does this have an impact on the hierarchy of norms, of the structure of norms? Are we going to introduce new types of rules that maybe can derogate other rules that have not the previous approbation by the Congress? What are your thoughts on these 2 points? Thank you.
I mean, the idea of defining major rules and distinguishing them from other rules is not new with the Reins Act. It's in the CRA. It's been something that OMB has been doing now for about 30 years, I think, maybe, right, about. So it's a threshold that's a rough threshold that's been applied internally in the executive branch for decades. And if you recognize that you want to distinguish between the agency actions that are of large consequence, that have significant policy implications, from those that don't, using the threshold and the definition that the executive branch itself has been using for decades seems to be a reasonable thing to do. And now, is 100 million the right number or not? We can debate that. It turns out there aren't very many rules that are right at that threshold. You talk to people that are at OIRA, and there's a small percentage of rules that clearly exceed that threshold, no matter how you're calculating the numbers. And then there's the vast majority of what agencies are doing, which come nowhere close. And you kind of have two clumps. And so altering the threshold on the margin really wouldn't have a significant, certainly raising the threshold a little bit, would not have a significant effect on the number of rules that are subjected to this process. It is capturing, I think, reasonably cleanly the distinction between the really big decisions that agencies are making and the little ones that they're making. And again, for reasons I've already discussed, I think as a normative matter in terms of thinking about where agency power comes from, it makes sense that the principal pays attention to the big things, right? If you're a company and you delegate to some vice president the power to make certain sorts of acquisitions, it's totally natural that you would say you have the authority to make acquisitions up to a certain size. But if you're going to make an acquisition larger than that, something that might affect the overall financial health of the company, then we expect you to come back to the board. And we'll have some rough criteria for that. We'll use a dollar figure, we'll use something else. But that's a normal way of managing an organization, and recognizing that the principals that are the source of the authority care about big decisions, but don't have the time, expertise, or desire to be involved in every little decision. And so I don't think there's anything particularly unusual or normatively problematic in embodying that principle in a form of legislative review, or embodying it in a legislative review mechanism.
The $100 million figure, if I recall correctly, goes all the way back to Executive Order 12866. So it's been around for a while, and perhaps it is time to adjust it, although, as Jonathan says, that might not do much. You mentioned non-major rules. I just do want to point out, this is a small thing, but there is just a drafting error in the Reins Act on non-major rules, which I've written to Senator Paul about a couple of times. Section 802 says that non-major rules shall take effect as provided in Section 803. Section 803 does not say how non-major rules shall take effect. It provides a mechanism for Congress to block them, but it doesn't say how they shall take effect. So Section 802 saying they shall take effect as provided in 803 refers to something that doesn't exist. So maybe someone in the audience can get that fixed.
I have a really quick comment on your other question about whether you might be introducing a normative hierarchy of rules. I mean, there's nothing in the bill that does that, but I think I can imagine, and maybe this is actually a good thing. Someone earlier was saying that if Congress actually approves a rule, courts on APA review, even though the Reins Act doesn't alter the standard for APA review of that rule, I think are likely to be rather deferential to the policy judgment that Congress has approved, particularly if you're talking about arbitrary and capricious review. I can then imagine that in later litigation or challenges about involving a non-major rule for its consistency or inconsistency with a major rule, because agencies are supposed to harmonize their explanations for what they're doing, and arbitrary and capricious review can involve when you don't make a reasoned explanation of how your rules are consistent or how your policy judgments have varied over time. I can't imagine that courts would think that policies embodied in a major rule and approved by Congress have a greater weight than an agency's explanation of its policy judgment in a non-major rule. That is a speculative answer, but I think you are right to foresee that down the road if that were to happen.
Okay, well, I think we are, one more question? Okay, one last question.
Well,
Yeah.
I'm Dave Rosker, SBA Office of Advocacy. Just quick correct the record, the $100 million goes back to Executive Order 12291 in 1981, so it's been a while since we've adjusted that for inflation. I'm interested in how the Reins Act would have changed Congress. A lot of what we've talked about is how the Reins Act would rein in agencies implementing old statutes, but Congress continues to write legislation that requires significant agency rulemaking. For example, we had major TSCA reform in the last Congress. How would the Reins Act change Congress's ability to pass legislation, recognizing that every significant agency decision has to come back through the Congress for essentially re-whipping of the vote?
I think it would change. I mean, there are a lot of ways I think it would change Congress. Right now, Congress, in at least some instances, we can debate about how often this occurs, punts the hard choices to the agencies, knowing that whatever the agency does, they'll be able to complain about it, right? Clean the air and make it cost enough, and don't make it cost too much. And if the agency adopts a really expensive rule, I said don't make it cost too much. The agency adopts a rule that's not environmentally protective enough, we said protect the environment. And we see, as someone who lives outside the Beltway, I see this in my local papers all the time, right? Members of Congress will say, no matter what the agency did is not what they told the agency to do, because that's the way they avoid alienating with some part of their constituency. So I think the Reins Act affects that. I also think that if Congress knows its ability to avoid accountability is lessened because the big decisions under a statute are going to come back to it, Congress might recognize that maybe it might as well just deal with the tough problem up front and in the statute itself. Am I sure that's the way Congress would respond? No, I think that is a plausible account. David Schoenbrod has written pretty extensively about how the practice of delegating authority to agencies not only allows them to evade accountability, but in some concrete cases probably delayed significantly positive things that Congress and the agencies eventually got around to doing, but it resulted in it being delayed for no good reason. So, for example, he argues, I think somewhat convincingly, the lead phase-out occurred much later because of Congress's punting and delegation. And I think the Reins Act would create some incentives to not do that, and I think that would result in greater accountability and perhaps better lawmaking.
I think it's a great question, and I'll add one other way that Congress should change and would have to change, and that is in response to Jonathan Siegel's point about perceived lack of expertise or perceived lack of expertise. When I remember after CRA was passed, the earliest version of Reins, it wasn't called that then, was being shopped around, and there were committee chairmen saying, we don't have the expertise to make this sort of judgment. I was shocked. And my first reaction was, you have an administrative record you can review, you have all the comments you can review, this is just an we don't have the expertise. I was shocked, and I said, well, you better damn well get it. If you don't have the expertise, and that's probably right, then what is that shows the inversion of the separation of power ideal from what the framers intended in the grossest of ways. So one of the other important thing that Reins would do is, maybe we libertarians like small government and small Congresses, and Congress is kind of bad and the most dangerous branch, but compared to the administrative state, I want to arm Congress with the expertise to be able to confidently make an up or down judgment or send it back to the agency for a redo.
I think you'll get something called the Reins waiver, Right, that is how it will change Congress, is in every new piece of authorizing legislation, a new chip created by the Reins Act, which will be bargained for in every single major piece of authorizing legislation, is what will it cost to get the Reins waiver, which will go into every single such bill, into the bill, right? And so that's more or less how it will change Congress, I think.
That's why we need the Hill veteran. Okay, thank you very much to our panelists.